Three, two, one. Welcome to the live broadcast here today. Well, it's not going to be live because we had a little bit of problem with LinkedIn Live, and now we're recording it on Zoom. I'm Digit Murphy, and I'm co-founder of the United Women's Sports NIL agency, and we care about women. We care about sports. We care about the future of women in sports, and NIL is the topic of discussion today. I am here today with a very old friend. Should I call you counselor? Counselor Leigh Ernst. And
Friestedt.
Friestedt.
Yeah.
It's a hard name to pronounce. There's a lot of like vowel consonants that are like together. So Leigh, welcome to the podcast, to the seminar, whatever we're calling it. Welcome.
Thank you, Digit. I very much appreciate joining you today.
Cool. So, you guys know who I am. I'm going to tell you a little bit about Leigh, Counselor Ernst Friestedt. She's the founder of Equity 9, a boutique law firm that specializes in Title IX, women's sports and education. As a former student athlete at Brown University, where I know her from, she was a lacrosse player, I think.
Yes, correct.
I knew that because of all the pictures you took for UWLX. And Leigh is uniquely qualified to advise universities, student athletes, and coaches on legal matters surrounding Title IX, gender equality, and NIL, name, image, and likeness matters. Prior to forming Equity 9, Leigh was with a mergers and acquisitions investment. She was a merger and acquisitions investment banker on Wall Street. I'm always so impressed by that, like unbelievable. And she has over 12 years of M&A experience advising global companies across all sectors with specialties in media. Leigh, like you're a stud. You're like someone that every woman should want their daughter to be. So I am so pumped to be having this conversation with you.
Well, thanks for the big compliment, Digit. And a lot of what I do today is to try to help educate younger women in terms of the opportunities for them when they want to play sports in school. And so I definitely welcome the opportunity to speak with you and your audience today.
Yeah, well, anyone that knows me, we're all about opportunity. We're all about Title IX and the House case. First of all, can you just tell people that this is not the House of Representatives? Can you just talk a little bit about the name of the House case? Because everyone I talk about is like, it's a Congress. I'm like, it's not Congress.
No, it's an athlete. It's a student athlete. He's a swimmer. His name is Grant House, and he is a swimmer from Arizona State University. And so House is simply his last name, and it is the named plaintiff in this class action lawsuit right now. The current House settlement, Digit, is actually a consolidation of three other major NIL lawsuits that have been consolidated. So there are lots of other plaintiffs in here. Hubbard, Carter, Sedona Prince is one of them. You know, you might remember her. She was the Oregon basketball player. So there are lots of other named plaintiffs as part of this NIL consolidation of the class action lawsuits against the NCAA and the Power Five conferences.
I mean, this stuff to me is fascinating, and we've been talking about it for a long time, but it kind of snuck up and it got settled recently. So can you kind of walk the layman through what is happening? Because it's funny, I sent this live LinkedIn I'm going to do, which is not live, which I'm a little mad about. As you can tell, I'm mad about that. I sent it out to athletes and they're like, what is this? How do I do this? And like, it's since 2016. So like there's a lot of kids, well, former athletes, I call them kids, that are affected by this. Can you talk a little bit about it before we get into the slide, or should I put the slide up? You tell me.
No, we can talk high level before we get complicated with a lot of the slide. So at a high level, Digit, the NCAA all along has had eligibility rules in terms of what you need to do so that you're eligible to play D1 athletics. And one of the major eligibility rules has historically always been that student athletes need to maintain their amateurism, and as part of that, they cannot get compensated. So that is where this all stems from. The reality is that organizations like the NCAA and the athletic conferences and the universities themselves have in fact been monetizing off the student services, but for having student athletes play on a field, you don't have a product for the NCAA to sell. So this whole lawsuit is about an antitrust violation by the NCAA because of the NCAA's eligibility rules, which have prohibited student athletes forever from monetizing for their services and for their name, image, and likeness. And, even more relevant, it's like, hey, you're a student athlete, you've got your own social media page, you can't even set up your own sponsorships. So all of those rules and regulations are what the courts are saying, no, NCAA, this is an antitrust violation. And so that's really what this is all about.
Hmm. Wow, there's a lot to unpack there because I remember the days when you couldn't even give someone a pen and it was a violation. Now they're paying the kids. It's crazy.
Yes.
Like when we started out. So talk to me about this lawsuit and the settlement that actually happened and how it affects student athletes. So should I bring the slide up
You
or
can,
no?
uh,
I'm gonna
you can bring the slide up. Bring the slide up. I don't want to complicate things, but certainly bring up the slide quickly.
Can you see that?
Yeah, see if you can go down a little more.
Down.
Yeah,
Let me make it smaller.
yeah, okay.
Okay.
Yeah. Okay. So yeah, the House settlement again is a consolidation of multiple antitrust lawsuits against the NCAA. And this actually if we step back a level, started with like Ed O'Bannon. I don't know if you remember him, but he was like this, I think he was a big time basketball player out of UCLA. Well, he and his buddies were playing video games in college, and all of a sudden Ed realized, oh my goodness, that's me on the screen. So when you think of
Wow.
name, image, and likeness, EA Sports had created this video game character that had the same jersey, had the same number. It was Ed O'Bannon, but he wasn't getting compensated at all for it. Instead, EA Sports was, and even his school was. So this all started back in 2015, and that's really when the courts started saying that this is illegal for the conferences to be monetizing off the student athletes. Fast forward to 2021, Digit, there was a huge lawsuit that was settled, went to the Supreme Court. It was actually a unanimous decision. It was called the Alston case. You may be familiar, a lot of student athletes get what's called Alston payments now, typically in the order of magnitude of $6,000 cash payments to student athletes beyond their scholarships themselves. This is all because in 2021, the Supreme Court unanimously, in their decision, called out the NCAA for effectively acting like a cartel and basically with their eligibility rules being anti-competitive. And so as part of that, that's when it really opened the floodgates for student athletes to get compensated. And that decision was like on June 21st, 2021, and June 30th, less than 20 days later of that month, the NCAA immediately had an interim NIL policy. So that was really when student athletes started to, above the board, get compensated for their name, image, and likeness. And
that was pretty quick. Can I stop you right there? I just want to comment on that.
Yep.
I remember when we were trying to get anything through the NCAA back in the day, it took a million years. How quick did that happen, did you say?
I think the decision was June 21st, 2021, when the Supreme Court released their decision. And on June 30th of that same month, the NCAA already had an NIL interim policy.
So that's pretty quick. This has a lot of juice. That's what it tells me.
Yes.
Okay. Keep going. Sorry to interrupt. I had to comment on that.
No. And it's like I said, that's when the floodgates open and people realize that, wait a minute, we can compensate our student athletes. And that has like manifested itself in lots of different ways. As we talked about, there are Alston payments now for student athletes in college. There are these collectives that you may know about that are forming next to all these universities, which are basically pooling cash from donors, from fans, from sponsors, and then the collectives are directly compensating student athletes to help recruit them, to help retain them. That is an example of how the floodgates have really just opened in terms of the monetization that student athletes can now monetize off their athletic services and their name, image, and likeness.
Dave Zacconi and the lobster parties, he's like rolling in his grave right now. Can you
Yeah.
imagine Dave Zacconi with this kind of juice? Like Brown would have been a number one in the world. Any of you Brown people out there listening know who I'm talking about. So keep going.
So we had the floodgates open for student athletes to get compensated in 2021. There were a series of other antitrust lawsuits in the pipeline already, and everybody was all of a sudden saying, "Wait a minute, I'm one of those athletes that made tons of money for my school in the past." Historically, the money that gets generated for universities and for the NCAA is primarily in men's football and men's basketball. And increasingly in the last year, we're finally seeing women's basketball get added to this equation. But if you understand the economics behind how the NCAA and the universities run their athletic budgets, there's a reason for that, because the NCAA generates approximately $1 billion a year, and just round numbers, approximately $800 million of that usually comes from the NCAA men's Final Four championship. And that money actually gets distributed back, Digit, to the universities themselves. So that's why you have this whole symbiotic relationship between men's basketball being such a powerhouse sport, why the schools are focused on having, a strong men's basketball, team, because that can help generate, based on their pro rata share, a higher percentage of money coming back to them from the tournament. And then conversely as well, the football is independent, but obviously they have huge football contracts with broadcast networks and sponsorships. So again, those are the two major men's teams that have been generating revenue for the universities and for the NCAA and athletic conferences. But in reality, it's important to keep in mind that there are approximately like 1,100 schools regulated by the NCAA. Only about 20 of them actually make money. Like after you cover your expenses, 20, about 20. Yeah.
Woo.
So, there's a big misnomer that all of these schools make money. They will always say, well, we have, a men's basketball, a good basketball team. But in terms of your overall athletic budget, your basketball team may be contributing more revenues, but they're still covering lots of expenses. So, my point of that is all of these schools, like some of them make a lot of money off of sports, but they have huge expenses with their athletic.
Even with those $1 billion or whatever you said, the TV rights and everything, even with those.
Well, so the only schools that are really going to make money are the big time,
BCS.
like the Ohio States off the top of my head, the Georgias, the Alabamas, things that have really big broadcast, agreements in place.
Okay. So when Bill Belichick goes down to North Carolina, they're really not making money.
No, I'd have to look at UNC's numbers, but I don't think off the top of my head that UNC is one of the schools that generates a profit off their program. I'd want to check those numbers, but
you're spoken like a true lawyer. I like that. So let's get into how this impacts women, because we talked a lot about men's sports, distribution of cash, how the NCAA makes all their money. How does this specifically affect women in Title IX?
Yeah, so I think I think to answer that properly, Digit, I think it's important to kind of understand what is going on with the money right now as part of this House settlement. And this is where this slide can kind of come in handy here. The House settlement is got two components to it, Digit. Number one is going to be back payments for all the student athletes, male or female, from 2016 to 2024. And again, this is an order of magnitude of $2.6 billion that is going to be paid retroactively to all of the student athletes. So that's the back payment settlement. Now, question?
Where do they get that money? Where does the back payment money come from?
Excellent question, Digit. The back payment money is actually going to come from the defendants in this case. And the defendants are the NCAA, the Power Five conferences, but in addition to that, all of the Division I member schools, i.e. colleges and universities, who are a member of the NCAA. So, for example, Digit, you and I went to Brown. Brown is not a named defendant in this case, but they are going to have to contribute an amount to this actual settlement case because they are a member school of the NCAA. So this is why every
university. Two things. Number one, I went to Cornell.
Okay,
just kidding. We were at Brown.
Brown. My apologies.
I'm sorry. I'm kidding. I just had to say that as a joke. But like, how do they decide how much? Like, because Brown's like, they're never going to have any share of money. Like, how do they decide which schools and how much they pay? Or do you know that?
Well, this settlement has taken 2 years. Okay, so there's been extensive economic analysis in terms of the settlement numbers. And my understanding is the NCAA has a number, the Power Five conferences have a higher number, and then basically the schools, depending on which conference they're in, I believe,
have like a smaller number.
It's a set number, in terms of, I assume that the Ivy Leagues are all, paying the same amount of number, the same number.
Because I would hate to have like sports be, and I don't know if this could ever happen, sports be taken away from these smaller schools because of the crazy NIL stuff that, in my opinion, and again, I'm giving some commentary here, sports should be about education and not about money. But okay, you're back to you.
Yeah. So, as we said, the first part is the damages settlement that's going to go retroactively to D1.
Back payment. Yep.
Okay. The front part is called the injunctive relief. And so the class of athletes who are eligible for this or who this is going to impact is actually all the D1 athletes from 2025, which, as you know, is going to be very soon, for the next 10 years after this settlement agreement gets finalized. So I'm just putting in here 2025 to 2035. So all D1 athletes. And this injunctive relief is really important for really two reasons. The first thing is that as part of the settlement, the courts have told the NCAA they need to change the rules, the NCAA and the athletic conferences. You need to change your rules and you need to basically let the student athletes get compensated. Okay, so the NCAA has to change the rules. The second component of that is that the courts have looked at the scholarship caps that existed in the sports historically. And they have said that scholarship caps, say, for example, women's lacrosse, we have 40 players on a team, you're only allowed 11 scholarships. They're saying that cap is anti-competitive. And so they're requiring the schools to lift their caps. So the NCAA must also change their rules. So they are moving from a scholarship cap to a roster cap. And this roster cap is actually very important right now because, for example, the number of football players that are going to be allowed on a football team, if you have a top football program, it might have 130 male athletes on it. It's going to get reduced down to 105. So there are a lot of sports where the number of athletes that they have on their current team, men's and women's sports, is getting reduced down to a lower number. So this is a very important component. It's also greatly impacting the recruitment of student athletes right now. The oral commitments that we're seeing with student athletes, several of them have been reneged on right before signing days, which is a little bit unprecedented. And all of this has to do with the house settlement terms that are required. The other component of this injunctive relief is actually the schools could, if they wanted to, pay up to $20 million out of their own budget, to their D1 athletes. No school is required to do this, but for example, for the big time football and basketball schools, they are proactively looking to have $20 million extra in their budget, which they don't have that money right now, but they're trying to generate it so they can really recruit and retain the top student athletes in a world where student athletes can be compensated.
Wow. This is unbelievable stuff. And it's, we may have to do a couple of follow-up of these so that, we can continue to get people to understand it. Maybe we say it 5, 6, 7 times because it's a lot to unpack. I want to go back to the roster caps. Okay.
Sure.
So one of the prongs of Title IX is participation numbers, right? How it reflects student athlete population. So if Brown University has 40% men and 60% student body, you're required to have 40% male athletes and 60% female athletes, correct? That's the one prong, correct?
Yes, that's a substantially,
Simple,
yes. Yep.
simple. Okay. So does that, like, will schools now stop measuring it that way and change it to a different prong, in your opinion?
No, I mean, I think the three-prong analysis digit dates back to Amy Cohen when we were at Brown University, and she courageously sued Brown successfully. That went all the way up to the Supreme Court, who did not hear the case. But that is where we established the three-prong analysis
Mm-hmm.
that enables a school to indicate that they are in fact in compliance. So the first prong that you're referring to is substantially proportionate. So basically, as you said, that the number of athletes that you have at a school should be substantially proportionate to the number of undergraduate enrollment. It does not have to be identical, but basically, if you want to have like a silver bullet to indicate that you are in fact in compliance with Title IX, that would be the first prong. And that I would not anticipate to change at all. That legal analysis has been in place for decades now.
So when they institute roster caps,
Yeah.
right?
Yes.
And potentially who's going to lose in that situation? In your opinion, you don't have to, this is just an opinion
I mean,
piece,
it's
not
fact.
fact.
This is where my background in Wall Street comes into place. Sometimes it's just facts. Again, the NCAA is moving to a roster cap number, and we talked about football is only going to be permitted 105 roster spots. So a lot of these schools are having to quickly reduce their head count by 25 student athletes. Now, in many instances, for example, in football, you might have actual walk-ons. But in other schools, like other sports, again, I know lacrosse, our women's lacrosse number is going to be around 38. So many of the top teams may have more than 40 student athletes on the team right now. That is going to be 38. So there are two ways that a coach needs to manage his or her roster at this point. They're either going to need to reduce some of the current student athletes, or they're going to need to reduce the number of student athletes that are being recruited and coming into their system. But all the schools right now are closely monitoring their rosters in anticipation that if this House settlement goes through in April, that these roster cap numbers will in fact be in place next year, and that they will have to comply with them.
Perfect. So now, can we get into this, the settlement deadlines and how this is all working? Because I think this is what we've been leading up to.
Yeah.
How does it impact the student athletes that are listening to this? Some of the NIL future student athletes. So can you just take us through first the collegeathleticcompensation.com website? I think we'll explain all that. You've explained it to me, but I got to hear it again.
First, so basically, the U.S. District Court has issued a class action notice. So again, in theory, all Division I athletes from 2016 to 2024, in theory, should have been notified that they are potentially eligible to receive a payment because they are a class member. Okay. My understanding, just speaking with a bunch of student athletes, is many of them have not received any sort of formal notification. But one of the reasons why we're here today is trying to help educate all men and women just in terms of helping them understand this process. The official website that the court has issued is www.collegeathletecompensation.com. So every D1 athlete from 2016 to 2024 should be going on this website. And if you look at the dates starting December 17th, which was just 2 days ago, that is when the college athletes in theory should have been able to see the amount of money that they would be eligible for. Again, these payments are going to come out over the course of the next 10 years. But one of the components to access your site, you need an NCAA eligibility number. I think many of the athletes don't have this. So, we're in the process of figuring this out with athletes, but this is the website where they need to go. They need to figure out what they would be entitled to. And then in terms of the next steps, there are 4 things that the court has.
Wait, before you get to that, I have a question that relates to, their eligibility number. Okay.
Yes.
If they don't have that, what do they do? Do they call their school?
So I have student athletes that are, some of them are reaching out directly to their compliance officers, their coaches. In reality, those, I'll be honest with you, those individuals may not have their NCAA eligibility numbers. Every student athlete should know that he or she is actually also represented by both of the plaintiff's attorneys, and they have actually named associates in each of these two law firms. One of the law firms is Winston Strawn, based here in New York. Jeffrey Kessler is renowned as a top attorney. So he has named an associate. So any student athlete can also reach out to one of the two law firms and say, hey, I'm having a hard time figuring out what my NCAA eligibility number is. Is there somebody that can assist me with that? So I just, all students should know that you actually, in theory, have some representation out there. And I think they're also in the class action notice itself, Digit. I think that there is some other coordinator that's supposed to help student athletes, but this, at least from my understanding, is a gating issue right now for people.
So we'll have to get this in the show notes or something like that and tell students. Okay, keep going now. Let's pretend that your school did everything right. They said you are eligible. They notified you. You now have your NCAA eligibility number. I'm a woman athlete. I played at Brown. I'm looking for my money. What happens?
Yes.
Okay, let's not say Brown because they probably won't get any money. Just kidding.
No. I mean, I think the first thing too is it's important for students to understand it's actually not their university that's responsible to notify them. Okay.
Ooh.
So to the extent you're not getting a notification, you don't need to call your compliance person and start kicking and screaming. What the universities, they did have a deadline in the fall, and they were supposed to provide, I think, the NCAA and the attorneys all of their student athletes information dating back to 2016 to help build the database of the class. So just to the extent somebody's not receiving notification, again, this is not your university's fault. This is part of the class action not properly notifying their class members. So that's step one. What was your second part there, Digit?
My second part was, now they have all their information. Yeah. What do they do?
Okay. So they have four options. Okay. And
again, first they go to the website.
They go to the website. They, in theory, get their number. Okay. And I don't even know, there's guidelines in terms of what these numbers are, but it is anticipated, for example, that men's football and men's basketball, those student athletes are going to get a much, much larger number than somebody who played lacrosse. So these are rough numbers, rough estimates, but it is anticipated that men's football will get approximately 75% of the back payments, that men's basketball will get approximately 15% of the back payments, that women's basketball will get 5% of the back payments, and then all additional sports, men's and women's, all those other sports will only get 5%. So if you're not if you're not a basketball or football player, the amount of money is probably going to be pretty small. I honestly don't know exactly what those numbers are. But I would encourage student athletes to at least figure out what those numbers are, talk to your friends, see what their numbers are. Are they the same? The numbers should reflect how many years you played on a team and what conference you were in. So again, we're in the process of trying to help student athletes figure out what their numbers are.
Okay. So I would suggest right here on this show, if it's a show, a webinar, whatever we are, I think I'm going to put up as a podcast link, maybe. I think we should tell them to contact you or me and be like, let's start that database. Let's see who got what, because someone's got to keep track of this, right? Or the lawyers. I don't know. Like we have to track this. We need data. Data equals power. Okay. I don't know. Let's do it.
Yeah, I mean, I think I would encourage student athletes to be open with their numbers, because I think one of the things when we think about the options in terms of what the student athletes have in terms of their settlement options, there's four components, which I think makes sense to discuss at this point, which is the first one is they do nothing. And that's the scenario that I'm a little bit concerned about at this point, because I feel like a lot of student athletes probably aren't aware of this. And so in the event that they do nothing, they're likely not going to get any money, even though in theory they were part of the class that was eligible for it. And they will also release any future claims. So in my opinion, doing nothing is probably,
The
the
worst
least,
thing.
yes, the worst scenario, but it seems to be a scenario where a lot of student athletes may be in right now.
Mm-hmm.
The second one is that they can elect to participate in the settlement. That's what we would typically think of as opting in to a settlement. And if they participate in the settlement, they would be receiving the amount of money that they would be eligible for. To actually opt into this, I think that a student athlete is actually going to, again, have to go on the official website, have to make sure their contact information is accurate, and have to indicate what the preferred payment is going to be. In addition to that, I would encourage student athletes when they go on this website to make sure that their information is accurate once they get their NCAA eligibility number. To the extent the years that you played is not accurate or anything is not accurate, or to the extent that you don't have an NCAA eligibility number or you're not in this thing, but you did in fact play D1 sports in this time period, you would have to file a future claims form so that it triggers you being part of the class. So my point is that to participate in this settlement, a student athlete is going to have to take a proactive act of going onto this website and confirming their information.
But
So that's
interestingly to me, though, if they opt in, they release their claims. So even if they took like $5 for the next, 10 years, they have no claims to potential future class action suits, correct?
that's exactly right,
Okay.
JJ. Yes,
Okay.
that's correct.
Okay.
Which, which gets us to the next option, which is they can opt out. They do not need to be part of this settlement. There are lots of student athletes who have formally opposed this settlement at this point by actually filing, lawsuits against the NCAA and the House settlement, saying, "Hey, this does not work for me," and giving the various reasons. So there are lots of student athletes that have formally opted out and have filed legal opposition to this. That being said, that's separate than the option to opt out right now, which simply means if you opt out, you're not going to get a payment, but you do retain your rights. So in the event that you think that something is not right legally, this is obviously an option that some student athletes and their attorneys are in fact pursuing at this point.
How long do your claims last? Like, is there a statute of limitations on how long?
It would depend on what claim you have,
Okay.
so
All right.
that's not an issue, I would say, for the majority of people right now.
Okay.
Uh,
Okay.
the next, and actually, you're gonna have to scroll down just because I want to make sure everybody knows that it's for educational purposes only. I don't want anybody to think I'm giving them legal advice. There you go.
Oh, there we go. We got to put that at the top.
Yeah,
We
you
got to
gotta
put like one of those
well,
things, like
I,
what's that called? Like that thing across
well,
educational purpose only.
it was on the bottom there, and I just wanted to make sure that everybody knew. I was just trying to.
Everyone, this is for educational. This isn't to make money. We are doing this as a public service because that's what we do when we're mission driven, right, Leigh? We are Title Niners from day one.
Actually, I do most of my work as pro bono, so I can really say that.
You're a gem. You're a gem. Thank you for everything you do. Keep going. We didn't go to the object. I
Yeah,
object.
the object is listen, I think this is a student athlete's opportunity to have a voice in this process. And the court has given specific guidelines. The judge has said, hey, if you don't agree with this, you don't agree with your number, you don't agree with the terms, you can write me in writing. And they have, the court has outlined specific guidelines and just explain to the court why you think the settlement doesn't work for you. And maybe it doesn't work for other people similarly situated to you. But not only do the student athletes have an opportunity to formally object in writing, they could also request to come to the actual settlement hearing and present orally to the judge and present their case to them. This is not suing. Objecting is not suing. It's just basically putting in writing why you object to this settlement. And as part of that, if you did that, you would not be releasing your future claims, at least at that point.
Okay. So, first of all, unbelievable explanation. Even the layman like me can learn this. Thank you for that. I look at this whole thing and a lot of it is like we talked earlier, skewed toward money, skewed toward men's sports. Do you think that at some point there will be future Title IX claims or claims that, do you think that may happen or
Yes,
it should happen?
well, so there's a couple of things that are happening right now. Let's talk about factually what is happening. There are attorneys that are filing formal injunctions expressing concerns that they think both the back payments and the future payments would violate Title IX. And the idea behind that is Title IX is an anti-discrimination federal law. It is not. It's not excused because you generate revenue. And so the concern is that in the world where men are receiving 90% of the payment and women are receiving less than 10% because football, we're talking about football and basketball getting 90% there. But that is obviously an overwhelmingly disparate number that's very different. So there's fair amount of concern that the payments themselves may in fact be Title IX violations. It's clear that the legislation was written and it was never contemplated to exclude actual cash payments, Digit, because again, historically, these were never permitted by the NCAA. What Title IX legislation does require is that schools provide financial assistance that's proportional to their student athletes. So for example, if you have 50% male athletes, 50% women athletes, their financial scholarships should look like 50-50. And that it's contemplated that this type of payment, the back payments, and also the future revenue sharing payments would be a form of financial assistance that attorneys think should in fact be covered by Title IX. So there's that concern with Title IX. And I think one of the things that is important for student athletes to understand is that as part of this settlement agreement, and it's actually in the settlement agreement and class action notice, a student athlete would specifically be releasing his or her, because Title IX, Digit, covers not just women, but actually men too. They would be releasing their Title IX rights by opting in to this settlement. So that's something that's important, and I know that's something that people are specifically requesting the court right now to not include the Title IX exemption.
So, a couple of things. What would you say to people who say, "Hey, it's okay because football's bringing in all this money. They're bringing in billions of dollars. The men's basketball Final Four, March Madness is bringing in all this money. They should get it." What do you say to that?
Well, I mean, listen, in a for-profit world, I would say, hey, you're absolutely right. If I'm advising a company on Wall Street and they're in professional sports or in a for-profit world, I would say, I get it. Spend your money where you can make it. But this is not a for-profit world. The NCAA is a not-for-profit. The universities are not-for-profit. The thing about a not-for-profit is not only are you supposed to, you don't have to pay taxes on the money you're earning, which is a huge benefit. But also, if you look at their mission statements for the NCAA, the athletic conferences, and all the universities, their mission statements don't talk about monetizing on sports. They instead talk about things that you and I espouse towards, which is like the importance of a student athlete and,
Leadership,
and
all that
sports
stuff.
should be a component of the educational experience. So, we're in a not-for-profit world. So using money as an excuse to justify payments that are overwhelmingly favoring a different sex is a problem, because that is deemed to be a form of sex-based discrimination. So that's the issue, and it's clear that since Title IX was enacted back in 1972, there was a lot of resistance early on. People immediately wanted to exclude revenue-generating sports when Title IX was coming through in the 70s. And so this has already gone through Congress multiple times. And at a simple level, these universities are recipients of federal aid. And one of the conditions for Congress providing money to help with education is that in return, it's an agreement not to use the money in a discriminatory manner. So that is the whole concept behind why, Title IX is relevant in an educational institution.
Whoa, that was well said. And I, I just have to throw this in. I throw it in all the time. Um, Copa 71 was when the Women's World Championship in Mexico City happened. There were 110,000 people. You guys should go out and watch that documentary for women's soccer. There were 110,000 people watching the games. And just like in 1972, so much resistance for women's sports. I don't know why. I mean, I know why. Equal Rights Amendment hasn't been enacted. Just saying. And for whatever reason, we just do not want to let women in the sports space. But that's just my charge. Not saying it's your charge, but we want to continue to grow opportunities. So I can't thank you enough for being here. I did have one last question because I went off on a tangent. Sorry about that. Ugh. Um, why such a short period of time? I'm looking at these important dates. It's like December 17th to January 31st. Like it's Christmas, there's holidays. It's like you got literally 1 month.
Digit, I don't know. I don't know the exact, this is where these dates are falling. Typically what I can say is they have this settlement for the final approval hearing. So I'm assuming that the judge wanted to have some time in between when, anybody who would be objecting to the settlement so that the judge would have an opportunity to review these things. So obviously there's some, play here, but yes, I agree. Right now it's it's December 19th, and I'm sure this is a little overwhelming for a lot of people. The reality is most people aren't going to come back until school, and that would be in January. So it is a quick turnaround, which is why we are trying to make an effort to make sure we try to educate people as best we can right now.
Yeah, so we want this thing to go viral. I don't know who we got to call. We got to call like Serena Williams or someone, or Angel City. We got to put this on there. All right. So call to action here? What can we do? How can we help? How can they get a hold of you? Let's talk about call to action.
I'm always reachable. I'm reachable at Leigh@equity9.com. If you can figure out how to spell my last name, Digit, you can always find me. I'm based in New York, and I work 7 days a week. I'm always available, even if I'm traveling. So if anybody has any questions, I'm happy to help them. I'm working with a couple student athletes right now. We're trying to help understand their options and get them their eligibility numbers, all the basics. But this is a learning process for everybody. There's a lot of moving parts in this. There's new cases every single day. So, I'm trying to do the best I can just to keep up to date. And so when we have these conversations, we can give people the accurate information. But again, I think the biggest takeaway for anybody who thinks that they may be in this class, I would really recommend that they go on the official website from the court, the collegeathletecompensation.com, and really try to make sure that you understand through there what you may be eligible for.
All right. Well said. So that's Leigh at equity9, EQUITYIX.com. That's going to get you to Leigh. If you want to get to me, I'm Digit at UWSNIL.com. We're going to put this up in as many places as we can. We're all about education, empowerment, opportunity, using sports as a platform. So, Leigh, I cannot thank you enough for being here, being part of this whole NIL discussion. Let's mic drop this thing into the next one we do, which hopefully will be in a few days. I want to get as many of these going, and we're going to get it live at some point. Okay? Promise?
Yes, we'll figure out the LinkedIn live between now and then, maybe.
All right. Maybe not. We'll just go something live. Facebook, Instagram. We're not really sure, but we'll get this up. All right. Well, I'm Digit Murphy for Leigh, Ernst, Friestedt. This is the UWS NIL show of the day. See you next time.
Bye.